Hello and welcome to the ACEDS UK chapter event, Navigating the Turbulence Experienced by the Disclosure Pilot. I am Emily Wiley-Ballard, Vice President of the UK chapter and e-discovery manager of the law firm RPC. Before I pass over to my fellow board member Melina to introduce our esteemed panel, I wanted to thank you on behalf of the UK board for attending this evening. I wanted to thank our panel for their time and wisdom and remind you that we are recording the session and also ask you to submit any additional questions you have via the session chat. This is a Q&A, so we hope to have lots more questions for our panel to answer. This event is our penultimate event of 2021. The next is our annual e-discovery awards, which celebrate and recognise the achievements of people and companies in our industry. Nominations will be collated in advance of the event and voting will take place live during the award ceremony on the 13th of December. We'll follow this by a networking event early next year in person. Please do follow our LinkedIn chapter page for updates over the coming days and weeks about our awards event, for the recording of this session and also to access content for every prior session that we have posted. I'll pass over to Melina now to start the session. Thank you.
Thank you, Emily. Hello from me, everyone, and thank you for joining our webinar today. I am Melina Efstathiou. I'm the Head of Litigation Technology for Eversheds Sutherland and a board member of ACEDS UK. Today, I have the pleasure and honour of being joined by Deputy Chancery Master Marsh, Ed Crosse, a partner at Simmons, and Charlotte Hill, a senior associate at Penningtons and president of the Junior London Solicitors Litigation Association. The Disclosure Pilot Scheme, which introduced major changes to the way parties conduct disclosure from the 1st of January 2019, was always a living pilot, with changes expected to be made to it during the course of its existence. If we took a quick trip down memory lane, this time last year, the Civil Procedure Rule Committee had just approved for a number of refinements to be made to the pilot. The changes proposed at that stage were relatively modest, mainly clarifications and tightening of the disclosure scope, and the feeling was that the pilot was still at a relatively early stage and therefore more time should be allowed before anything more fundamental was proposed. The key areas of challenge were around initial disclosure, known adverse documents, direction towards the use of Model C, and the simplification of the DRDs. Although the changes had been flagged since, the changes, forgive me, had been flagged since September 2020, they did need ministerial approval. So in the meantime, professional associations and law firms were re-engaged to provide more substantive feedback surrounding the improvement of the pilot, which led to July 2021, when the above changes got published in draft and finally came into force 1st of November 2021. Now, Ed, first coming to you. Could you please walk us through the key areas of focus when the committee were discussing implementing further changes to the pilot?
Thank you, Melina, very much. And thank you also to the association for inviting us back again to speak to you about the pilot, because we've been working very closely with you all right from the start, really, on shaping these proposals, which is why I was a little bit amused when I saw the title Turbulence Caused by the Disclosure Pilot Scheme, but it made me think of a different analogy, which is maybe more appropriate for today, which is think of those big clouds of data that we're now going to find you a way to navigate through instead, rather than turbulence. But anyway, so you rightly pointed out there were some initial changes made to the pilot at quite an early stage, I think, based on feedback from a report by Professor Rachel Mulheron. But since then, and earlier this year, the Chancellor asked for feedback on 5 key areas that were coming out in our discussions as being areas for potential revision. So firstly, what to do about less complex or lower value claims, and the feeling being, and the feedback we received, was that the pilot, with all its architecture, was proving to be too onerous and so much of a sledgehammer to crack a nut. So that needed looking at. further guidance needed on the framing of issues for disclosure, a really challenging but very important area of the pilot. We then had extensive feedback on the use, or I would say misuse, of Model C, and some challenges that people were facing in relation to narrative documents, which you see in Model D. What does that mean in practice for a reviewer? We asked for feedback about the operation of the pilot in multi-party cases. The point being, is it really possible to have a sort of one-size-fits-all approach if you've got 15 or 20 defendants with different cases against them? And finally, there was some feedback about the disclosure guidance hearing, and the main point being that they weren't really being used, and where they were being used, it wasn't really in the way intended. We were seeing sort of full day contested applications with leading counsel appearing, and that wasn't really what it was about. So that's where we got feedback, and that's where we invited feedback, and we had a lot of comments, drafting suggestions, a really constructive engagement by the profession, and we were able to carry that forward into some drafting proposals for the Rule Committee, which we put through in July for approval. And those were approved in September, and as you said, Melina, they came into force on the 1st of November. And that's really what we want to cover today.
Brilliant. Thank you for this. So let us begin by diving into the arena of less complex claims. As was, the pilot applied to the majority of cases in the business and property courts. This would include cases of relatively low value, where the volume and complexity of disclosure would typically be quite limited. The intention of the pilot obviously was to reduce the overall costs of disclosure, but feedback on lower value claims was that the pilot had actually added an unhelpful layer of complexity that served little purpose. In short, the pilot, to quote Ed, was turning out to be a sledgehammer to crack a nut. So Matthew, now I'm going to turn to you. Which were the problem areas that were immediately identified?
Well, thank you, Melina. Yes, thank you indeed for inviting me to join everyone today. Things don't always work out how you think they're going to. I say that because as the pilot was originally conceived, we envisaged that it would be applied flexibly and with a close eye to proportionality, so that it wouldn't be taken as a straitjacket, it would be taken as a flexible tool to use in all sorts of different types of claim. But that hasn't really happened, and it appears that less complex claims have been perhaps overcomplicated in a way which we didn't intend. The sort of problems that we've seen are really the ones you would expect. Less complex claim, there's a need to agree issues, perhaps the issues would be too many and overly complex. Model C being used too often and perhaps sometimes in an oppressive way, and also completing the DRD from beginning to end, whereas the notes tried to make it clear that that wasn't actually needed. You need only apply or use the DRD to the extent that it was helpful to do so.
And what was the approach to address the mentioned challenges, Matthew?
So what we set out to do was to create a simplified regime for less complex claims. And this is what we've achieved. It's set out in Appendix 5 to the practice direction, which takes effect, or took effect indeed, on the 1st of November. So the new regime spells out the way in which simpler claims can be dealt with, and it emphasizes they should be dealt with in a different way. So you ask the question, what is a less complex claim? It's one which is defined by really 4 characteristics taken together. When you look at a claim, is it just obviously less complex? So its very nature is less complex. Is its value less than the run-of-the-mill? Is it less complex overall? And is the likely volume of documents relatively small? And if it fulfills broadly those characteristics, then it doesn't need the full regime of PD 51U. And we've added a rider, which is an important one, that if the claim has a value of less than £500,000, then there's a starting assumption that it should be treated as a less complex claim. So this regime is in force. It can be opted into, or indeed, if necessary, if there is a dispute, the court can order that it applies. Although I don't think that's going to happen, in fact, very, very often. What is the new regime, you ask? Well, there are really two principal features. The first is that the regime specifies that the issues for disclosure must be limited to 5. Doesn't mean there have to be 5, but 5 is a maximum. There could be sub-issues, but only if they don't materially add to complexity. So that's the first major change. There's still a requirement to agree those issues before the CMC, but clearly the smaller the number, the easier that should be. And the second important change is that the only models that will apply to a lower value claim are A, B, and D. So no Model C requests, and perhaps obviously no Model E disclosure either.
Thank you, Matthew. Over to you now, Charlotte. Could you walk us through the approach towards the dreaded DRDs?
Of course. I think everybody will be pleased to hear that if you're dealing with a less complex claim, the DRD has been vastly simplified, obviously with the purpose there to reduce time and costs and to make the exercise in its entirety proportionate. So with that in mind, as I say, the working group produced this much simplified version of the DRD, and it really just deals with the data landscape and the scope of the searches to be undertaken. And so what's been removed are the various different sections. So we no longer have the section 1A with the list of issues, the section dealing with the Model C disclosure, because of course, as Matthew says, there is no Model C. And then quite a lot of the questions have been A, simplified, and B, consolidated. And so actually, when you look at it, in essence, you only have about 5 pages worth of a document to complete, although of course, you know, you can make of it what you want and how helpful it's going to be to your case. And so as Matthew says, because there's only 5 issues for disclosure maximum, with perhaps some sub-issues, but perhaps not if you don't need it, that obviously reduces a lot of the documentation to be provided. And then really you move quite quickly into the nub of the questions. And so the second question of the DRD, the simplified version, asks the parties to detail the data sources. That includes both hard copy and electronic documents in one question. But it doesn't ask more sort of detailed questions, such as detailing the bespoke use of proprietary software or things like that. It then moves on quite quickly. I mean, of course, it needs to deal with whether there are any unavailable documents or irretrievable documents. And then you really get into the nub of it, which is the search proposals. That's probably the meatiest section of this 5-page document, but it's still much, much shorter than the full DRD. And so really, I think will help for those less complex claims. And in it, it seeks the initial search proposals, of which then you're asked to give an indication about custodian files and date ranges and things like that. It, of course, encourages the use of technology, as it ought to, but it underlies that with, of course, the general principles that the pilot's seeking to achieve. And so it asks you to consider, you know, whether the use of technology would be efficient and proportionate, whether actually that's suitable, bearing in mind the number of documents in a review pool, and of course the estimated costs and the value and complexity of the claims. And so it concludes with the usual cost estimate section and the note of disagreement, and it's hoped that that much shorter condensed version will of course assist the court with the disclosure review, but make the process generally much more proportionate and efficient.
Brilliant. Thank you. Thank you for your thoughts. The second part of our discussion will now focus on the modifications to list of issues for disclosure, Model C and Model D, particularly around the narrative documents. Now, kicking things off with the list of issues for disclosure, Matthew, I come to you again. Could you walk us through the common approach towards this, the pitfalls and the suggested changes?
Certainly, Melina. I think I'd like to start by saying that although clearly this is an area where the professions have sometimes found difficulty. One shouldn't be overly negative. I mean, I've seen many examples of issues of disclosure which have been carefully worked through. They're not overly complex, they're not overly long. The parties have cooperated, and they've come up with a solution the court has been able to accept without any difficulty at all. We tend to hear more about the sort of horror stories rather than the cases where the process has worked entirely satisfactorily. But I think really the problems that we've seen, they really fall into 4 categories, I think. The first is where an overly contentious approach has been adopted by the parties. You put 2 lawyers in a room and they will disagree about everything. That's just in the nature of our training. It's not, I think, the best aspect of our training, but that's just in the nature of things. But when it comes down to wording, the wording of an issue for disclosure, does the precise wording really matter? What we should be concentrating on is the sense of it, of course, rather than the precise words used. And the parties have certainly very often spent a lot of time arguing about relatively small points of wording rather than, I think, concentrating on the sense of what they're trying to achieve. Of course, there have been, secondly, because over lengthy issues. The actual issues themselves have been not quite a novel, but anyway, getting close to a novel, and that's clearly not going to be very helpful. Thirdly, there's too many issues. Some cases we've seen over 100 different disclosure issues, and that simply can't be right, even for complex litigation. And the fourth point, I suppose, is that sometimes issues of disclosure are not really focusing on disclosure, they're focusing on the issues for trial. And it is really important to distinguish between those points which will need to be determined, which are really points of law, as opposed to those which will speak to documents in the disclosure process. So what we've tried to do is really more of a steer. We all have the Chancellor's decision, well, now the Master of the Rolls decision in McParland in mind. We didn't think it was necessary to set out what the Chancellor said in that case in the practice direction. But we have made it clear that issues of disclosure are not issues for trial, but there's nothing wrong with starting with the issues for trial and working backwards to issues for disclosure. That's a perfectly legitimate approach, and one which the rule, the practice direction accepts is a perfectly proper approach. The second change, and this is perhaps a statement of the obvious, it says that issues for disclosure must be concise. Now that does come from McParland, but it is a terribly, terribly important part, and I hope it is something everyone will take on board. And I think I would add this, that although I'm now going to refer to something which is in Appendix 5, which is part of the lower value claims section, it can, I think, be usefully applied, because in Appendix 5, in paragraph 10.5, we've tried to answer the question, what is the purpose of defining issues of disclosure? Why are we doing it? And it would be a useful thing, I think, for the parties to ask themselves in every case, what's this about? Why are we doing it? We have identified in that paragraph 4 reasons, or main reasons, why issues of disclosure are defined. The first is to help the court to decide whether extended disclosure is required, and if so, what models apply. The second is to assist in identifying documents that may be appropriate for disclosure, or types of document. Third is to help define the scope of searches. And the fourth is to assist the reviewer, so at the back end of the exercise, to assist the reviewer in determining documents which are relevant. And I think if those principles are cross-applied, as it were, from Appendix 5 and thought about in each case, it may be that the parties will find it easier to come to agreement about issues for disclosure.
Very, very interesting. Thank you, Matthew. I mean, I would hope that keeping issues for disclosure concise should come as a natural thing for lawyers, but here we are, we always need the reminder and maybe a word count to come with it as well. Moving on from your insights, we're now going to discuss Model C. Ed, please walk us through the challenges around Model C requests and the changes that have followed.
Yeah, I will. I mean, I just briefly endorse what Matthew said about Model C, where it works. I'd certainly confess in the cases I've handled, it is difficult drafting a list of issues, but actually if you approach it in the right way, it feeds through into everything else that you discuss. And I certainly have found it to be a really useful tool. In relation to Model C, I think the problem or the challenge that's arisen there has been that people have tried to apply and use Model C as if you would, in the sort of way you would make requests in an arbitration, so Redfern type approach, where you use the requests to interrogate the landscape of data and therefore end up with multiple requests and very broad requests. And that was never the intention for Model C. Model C came from the shorter and flexible trial scheme, which was a case where you said, well, look, we don't really need disclosure in a large number of areas, but we do just want to look here in these 4 or 5 areas. And that's absolutely where it came from and still applies in that process. So, if you're in the territory where you've got multiple Model Cs going across the data landscape, then you should really be using Model D. Now, I think part of the problem might have been that in the original practice direction at paragraph 6.5, it said where disclosure Model D or E is proposed, the parties should be ready to explain to the court why Model C isn't sufficient. And I think, what we had in mind there was Model C and then Model B, but not multiple Model Cs. So we've removed that to sort of de-emphasize the use of Model C and provided some further guidance about, limiting the number of Model Cs and thinking about whether actually Model D is more appropriate, but not Model D on its own, because you may have a range of issues. You could have Model D and a whole list of Model B, which is reliance-based disclosure. And there, with Model B, there's no searches required, and that's how you cut down the extent of the search and review task. So limited number, focused in scope and concise. You're not allowed to use broad formulations such as any and all documents. And you're not allowed to use Model C in a way that's sort of tactical or oppressive. So that's spelt out. Finally, we've changed the title to Model C, which may be more optics than real, but it does put the emphasis on disclosure of particular documents or narrow classes of documents rather than being a request-based approach.
Melina, do you mind if I add something here about Model C? Because it's a bit of a bugbear of mine. I mean, at a very crude level, crude analysis, disclosure can be looked at from a top-down level, or top-down approach, or to a bottom-up approach. And what I mean by that is if you know what documents are going to be relevant to a particular issue, and the classic example is, what was set out in board minutes between these dates is going to be material. It's quite useful just to identify that and to say, well, on any view, we need these. They're easy documents to isolate. You don't need complex searches to find them. So let's get them into the open. That's a sort of top-down approach. And indeed, it can help sometimes when you identify documents in that way, that in fact you can have disclosure in a graduated manner in a more complex case. The more bottom-up approach is communications between parties in all sorts are probably going to be aggregated into a pool and searched using the methodology which you're all familiar with, that sort of bottom-up disclosure. And that's perfectly valid and appropriate, but it shouldn't be used, as it were, to exclude the top-down approach for particular types of documents which are obviously going to be relevant. I mean, invoices in a damages claim, maybe a loss of profits claim, maybe another obvious example. There are lots of examples where you can just isolate the documents early on and ask for them.
Thank you, Matthew. I genuinely think that the lay terms explanation of top-down or bottom-up disclosure model works wonders. I do even vividly remember like a complex litigation case that we were involved merely from an e-discovery perspective, and it was a combination of Model C and Model D requests, and the top-down particular approach had to do with specific types of documents, a mere date range, and practically everything was immediately falling under the scope of disclosure. So no hard search terms, as you say, or no time and costs spent and wasted. From earlier conversations that we have had, the other key change made in this area was around the pre-case management conference timetable. Ed, back to you. Would you care to walk us through this as well?
Yeah. The pre-CMC timetable was really quite a challenging area of the pilot when we were first drafting it, because you have different approaches taken in the commercial court and in the Chancery division, for example, of when things have to be done. And trying to fit that in was tricky. And of course, you've got large or small cases. Meaning, the large cases, it may be a year or 2 years before you have your first case management conference. So at the moment, as it was, the practice direction had a fairly prescribed number of stages that had to be followed after a certain number of days. And quickly parties were having to apply for extensions or just agree extensions. And the other thing that happened was that things had to be done sequentially. So first, a list of issues, discuss, seek to agree that, then what models, and then Model C requests. And that process, if you calculate it out, could take up to 100 days. And our thinking had been, well, you probably need that amount of time to do it. But actually, what works better, and this was actually something that came from Herbert Smith as an idea from the senior PSL there, was why not have the claimant propose the list of issues up front, and then that party should really know what type of orders they want to have for those issues, because they're proposing the issue and they should know what order they're seeking. And if they're pushing for Model C, then they should actually say what Model C wording they're looking for. And the reason why that's important is you're asking the defendant to agree to an approach, both on the issue, models, and then Model C requests, sometimes before that party has any idea of what you actually mean by Model C as being the way of interrogating a particular issue. So what we've now provided is that all of those things are done at the same time by the claimants. There's a bit more front loading for the claimant, but they'd have to do that anyway. And then the defendant can reach an informed approach as to whether or not that sounds sensible. And I sort of cheekily road tested this on a case with a number of parties, and by agreement, we did it this way, and I've done it twice that way, and it works. It does work very well in getting you to a sort of common position earlier on. The other thing we've done is we've included some language in there to make it clear that you can vary the pre-CMC timetable by agreement, provided that doesn't impact on the date set for the case management conference. And lastly, that you may have a case where actually the claimant, despite being the claimant, is not really progressing things, and you as a defendant may actually want to get disclosure moving. And it says there, if you don't start getting any proposals from the claimant for whatever reason, you as the defendant can make your own proposals and take the lead.
Incredibly interesting as an approach, and quite liberating to see both sides being able to take hold of the steering wheel if need be, as disclosure and the timetable surrounding it should definitely be kept as disciplined as possible. Thank you, Ed. Let us move to the changes around the approach to the use of narrative documents. Charlotte, I'm sure you have a lot of thoughts to share with us. Would you agree that the new approach is a tad softer?
Yes, I do. I do think it's softer, and I do think it will be very helpful to most parties at the CMC, because I know both from personal experience firsthand and also having spoken with many other colleagues and professionals around this, that this is a very contentious area at the CMCs as to whether narrative documents ought to automatically be included with Model D. I think reviewers particularly tend to find it very difficult to subjectively decide whether a document is narrative or not while reviewing disclosure using the Model D process, and that's particularly so where in quite often these large cases you bring in a team of reviewers who are simply dealing with the case based on a sort of a brief that's been provided to them, and haven't been part of the case from day one, and so don't naturally know what would or wouldn't be narrative. So I do think the new wording that's been brought in from the 1st of November is extremely helpful for that purpose. And what that in summary says is that now, in the absence of a court order as to whether or not narrative documents ought to be included or not, the parties instead are encouraged to take reasonable steps to exclude narrative documents where it's reasonable and practicable to do so. And that's, of course, with the view to reducing the overall volume and cost of any review. So I do think it is softer, and I hope going forward it will avoid many arguments at the CMC and indeed in the run-up to it about whether narrative documents ought to be included or not.
Can I just, Melina, just briefly mention on that? I mean, the original thinking behind narrative documents was to try and deal with the situation of where a party was just dumping a whole load of irrelevant materials on the other side. And so we felt that we needed something in there that could help and give us a stronger steer that you just shouldn't do that. But Charlotte's absolutely right. Lawyers do agonize over the wording and what should be in, what should be out. Are they going to be criticized? So this sort of common sense approach, I think, to narrative documents is what's needed to hopefully strike that balance.
Indeed. And I think it's twice now throughout the course of this webinar that I've heard that somehow the reviewer and the proactive approach towards making the reviewers' lives a tad simpler and easier is coming closer, not just to the identification and redefinition of narrative documents, but equally, as Matthew was saying before, even when it comes to recalibrating our approach to issues for disclosure. I mean, ultimately, we do know that a heavy element of the cost does come from the document review and the legal resources and everything that entails. So it's really encouraging to see all of this recalibration exercise. Thank you for your thoughts, Charlotte. And in fact, ACEDS, we are soon to explore what lies at the other end of the scale from less complex claims, and that is your multi-party cases, which are typically high value, complex, and as their name suggests, involving lots of separately represented parties. Matthew, let's kick things off with you to give us some background, discuss the surrounding challenges and the proposed changes.
Yes, thank you, Melina. Perhaps it's useful to start by reminding ourselves that there's no definition of what a multi-party claim is. It can take all sorts of different shapes, but we're thinking generally of substantial claims and the typical, no more than that, the typical multi-party claim might be one where there are a lot of claimants. Say there's a failed investment scheme where there have been a lot of investors and they all have similar claims, but equally there may be a number of defendants, and so there can be a lot of claimants, each with, at least in part, discrete claims. Some of those claims against some defendants, but not all. Some against one defendant, some maybe against all defendants, but there are a lot of different ways of slicing the claim. And it's rather obvious that a highly focused approach to disclosure is needed in those circumstances. I said earlier that we thought the pilot would be applied flexibly, and perhaps we didn't get that message across clearly enough, because it's obvious that in cases of this type, a high degree of flexibility is needed. The sort of problems you get in a multi-party claim are not really very different to some of the problems that are experienced in other claims, in the sense that you still have a difficulty agreeing a common list of issues to disclosure. You still have, at least historically, excessive use of Model C, and you have what was apparently thought to be a requirement for a single DRD. Now, plainly, that's just not possible in a multi-party claim. It would be enormously complex to produce a document, a single document, which encompasses every different claim against the defendants. In our process of consultation, we, having recognised the difficulties that multi-party claims give rise to, asked our consultees for suggestions about an alternative approach or approaches. We suggested maybe some form of protocol might be useful. Although I think everyone agreed that something needed to be done about multi-party claims, no one was able to come up with an obvious solution. There was one suggestion, I think, that we should just simply go back to Part 31, but to be honest, that isn't really an answer because the same problems still arise. And indeed, Part 31 is much less specific, so it would leave everyone further at sea. And anyway, there are aspects of the pilot which are extremely useful to a multi-party claim as they are in other claims. It is useful to know what the principles are, the way proportionality works, what the duties of the parties are, and indeed to be able to apply the models to different issues. So there was no point just abandoning the pilot for multi-party claims. So in the end, what we've done is simply to say in terms that where there is a multi-party claim, it will be necessary, or it's likely to be necessary, for the parties to apply to the court at an early stage and to ask the court to develop with the parties a bespoke regime, a regime that works for that particular case. In all probability, in many multi-party claims, there will be a fully docketed High Court judge, not in every case, but that's very likely. And so the parties and the judge can work together to produce a regime that will operate effectively. I mean, rather obviously, having one DRD is not going to be a great idea if there are a very large number of claimants, a very large number of different claims, and an interrelationship between those claims and some or all of the defendants. But it's not possible really to specify what that regime should be. It needs to be bespoke. And I think our hope is that in the medium term, it will be possible with the help of the professional associations, the LSLA amongst others, to come up with a protocol which will help the court and the parties to produce a bespoke regime. Guidance seems to have been a rather concerning expression to use in relation to the pilot for some, but a protocol can at least give some tips about how to proceed, and then perhaps some specimen orders might be helpful based on what particular judges have done in particular cases, so you can see how it might work and then see how that might apply to particular cases. But any such protocol or guidance is for the future, and we'll have to see how that works out.
Mm-hmm. Ed, Charlotte, any additional comments from either of you?
Yeah, I think just briefly, one thing I would mention is that in the practice direction, we at least address one particular area where parties can and should think proactively of what to do on production of documents in a multi-party claim, and that's something you need to think about right from the start in your discussions with the other side, because if you've got several defendants, say in a construction claim, they may have completely different claims being advanced against them on a particular project. And is it really going to be necessary or helpful for one defendant to receive all of the disclosure that might be relevant to claims against another defendant? So we have included some language in there to say you should give thought to, production, what is going to be produced, to try and cut down the costs on the review side. But that's the only point I would add to what Matthew said there.
Yeah, I just think actually, to advance this and to have, as you say, Matthew, perhaps in due course, some draft sort of specimen orders and some guidance, I think would be extremely helpful. But of course, I think as practitioners, we have to remember it's our duty to be cooperative and to try to present those options as best as possible. So I think while having that input from the working group would be extremely helpful. Equally, we've got to remember as a practitioner at our end, the duty's on us as well to try and find a way through it to make it work for everybody.
Thank you both. And for the closing part of our discussion, the focus shifts to changes to disclosure guidance hearings. Matthew, I'd like to kick off the conversation by asking you if you felt there was a true need for change.
Me again, Melina. You're picking on me, surely.
Probably not.
So, disclosure guidance hearings. Now, I'm happy to talk about this subject. It's a subject close to my heart. When we drafted the pilot, we thought there would be a need for the parties to come and ask the court for help. In other words, not to come and make an order requiring disclosure to be given in accordance with certain search parameters and so on and so on, but to say, look, we're stuck. We just can't agree. One side says there are 143 issues to disclose. The other side says there are 7. We can't both be right. Can you please tell us what you think? That's obviously an extreme example, but it illustrates the point. I think slightly surprisingly to us, there's been seemingly little take-up for disclosure guidance hearings as we envisaged them, which was a very light touch, risk-free or almost risk-free so far as cost is concerned, guidance or assistance from the court, so little take-up. And I think there was also what I would perceive as a misunderstanding on the part of the professions about 2 quite separate things. One is where the court is asked to make an order. The parties are in dispute about some aspect of disclosure, and they simply, somebody issues an application notice and comes to the court and says, please make an order about whatever it might be, some aspect of search parameters, whether a particular repository should be included or whatever it might be, something's important. That's, on the one hand, the court being asked to make an order. On the other hand, the court being asked to give guidance. And so what we've tried to do in the revised wording is to make this distinction quite clear. So there's a new paragraph, which is 6A, which is headed Court Control, and you can get an idea from that heading. This is where the court is essentially telling the parties what the answer is, or telling the parties what they must do. And it says, amongst other things, that a party can apply at any time for an order from the court in relation to any aspect of disclosure, how the powers applies, the parameters of disclosure in all their manifestations. Disclosure guidance remains in paragraph 11, and we've tweaked disclosure guidance, hopefully to make it more useful and hopefully to encourage parties to use it. We've made it clear that you must issue an application notice, and we've removed the requirement that you say the parties have made real efforts to resolve a point. If you're just at loggerheads and are willing just to submit to the court giving guidance, then that's the sort of hearing you want. It will be fairly short, now a maximum of an hour. You're likely to get an order specifying what the guidance is, not telling the parties what they have to do. And our hope has always been that those who are involved in disclosure, not counsel, those involved in disclosure will come and ask the court for guidance, because after all, the people who are actually undertaking the exercise, they know what is involved, and you don't then have all this metaphorical leaning over your shoulder asking, as counsel, asking what your instructions are on a point, because you know what the position is. So whether these changes will lead to more of a take-up, I don't know. We've said that you don't need to ask for a hearing if you want guidance. You can ask for guidance on paper. So to take my ridiculous example, where one side says there are 7 issues to disclosure, and the other side says there are, what did I say, 142, you could just frame the question really quite simply. This is the case, this is what it involves, we think it's 142, here are our questions, here are our issues, we think there are 7. And really, I don't think the court's going to need a hearing to give guidance on that point. It won't resolve precisely what the issues are, but it will, I think, indicate pretty clearly the 142 party is simply just way off target. That can't be right, which may be then sufficient to enable the parties then to move on and agree. But who knows? It may be that the idea we had, Ed and I and the others involved at that stage, was just simply not a very good idea, and it's not what the parties want. And if that's so, disclosure guidance will wither and disappear. But I would be disappointed in what is intended to be a collaborative exercise, albeit one involved where there's a dispute between the parties. I would be disappointed if the parties don't feel able to ask for the court's assistance. But I can see that it is slightly counterintuitive when we're used to, or you're used to, coming to the court for decisions, and usually with a risk as to costs. We will see.
Thank you for that. It honestly left me thinking. No discussion on live schemes would be beneficial if we did not have some immediately identified next steps. So Ed, now over to you.
Well, hopefully you won't feel it's death by 1,000 cuts, but we are going to keep listening and we are going to keep making changes while we can. It is a pilot, and that's, as Chris Dale pointed out on a post, I think on LinkedIn, you know, that's the beauty of this pilot, is that we've been able to respond to feedback and hopefully improve it and refine it. Now we've got another year and 2 months, at least as it's currently extended. And our plan is to continue to engage with users and the profession through events like this to get more feedback. And we continue to receive emails that we're collating and feeding through. So there will be an opportunity, we hope, in the spring of next year to step back again, reflect on further feedback and think about whether there are further refinements that can be made usefully. And we'll be engaging in particular with the judiciary to make sure that they get their feedback in a number of different areas that we're exploring to build on what we've already got. And then I think, you know, there will be a moment where a decision will need to be taken. We're not there yet as to, you know, how the pilot should proceed, whether it should be by way of a formal rule change to Part 31, or whether actually we feel that more time is needed for further improvement of the scheme. So that's really what it is, and that's why we'd continue to encourage, you know, all of those on the call, and particularly the association, to look at things like the DRD and think, you know, can we reshape that? Can we make it more user friendly? At the moment, it appears in a Word document. Can't we have something that is cloud-based, for example, that where parties can update it, you know, online? The solutions like that would be really great. So please do feedback.
Perfect. Charlotte, any closing comments from you?
I mean, I was just thinking, I think it goes back to actually something Matthew was saying earlier. I think it's key, having witnessed it both in my position as sort of senior associate and as the president of the JLSLA, hearing from reviewers and obviously sort of looking and overseeing and managing the strategy behind the actual disclosure itself. I think it's very important to remember both the bottom-up and the top-down approach. And I think you need to bring them together in parallel to make this process work. And I think actually the message that was said earlier about making the process as simple as possible for the reviewers really will make the pilot and just generally the disclosure process much more effective, so long as we of course don't lose sight of what's needed in the case overall. So I think just having those two things in mind together will you know, make much better use of the pilot than perhaps has been so far.
I couldn't agree more. And for what it's worth, I mean, my limited exposure in terms of not from a practicing the law perspective, but from getting involved in the heavy duty electronic discovery exercises. This is why, in a way, Matthew rendered me quasi-speechless, because it's not often that you get the courts lending us their time, or offering the time at the very least, to say, we're here for some proactive guidance. And the key term I take away from that is actually collaboration, because I hate to say it or to even admit it, but more than often we see that a lot of issues that could have been tackled by way of securing guidance and avoiding ambiguity are often literally trying to be ironed out at the eve of the CMC, which is definitely not the time and the place to go down that route. By engaging in a productive dialogue, even if it's going to end up potentially not rendering necessarily all the answers you are hoping for, either side of where you might be on a dispute, I think it's really important that later on you have a much more structured and an articulated CMC, and then of course you can proceed with a more productive approach when it comes to disclosure. Matthew, any closing thoughts from yourself?
I think I just add that Ed and I, and there are two other members of the working group, are heavily involved in doing quite a lot of work, but we really don't have any control over the direction of travel for the pilot. We may have views, we may make suggestions, but essentially members of the senior judiciary, particularly the Chancellor of the High Court and the Master of the Rolls, will decide what's going to happen to it. And we genuinely are not privy to their thinking. So we don't know where we're going to end up. But what would be nice is if wherever the pilot goes, we have made it as good as we possibly can. I don't think now anyone seriously argues that Part 31 is an ideal regime. It has huge gaps in it. It is very out of date and rather messy. But whether the pilot's the best thing we can come up with, that's open for debate. And I would strongly encourage anyone who thinks there is a better idea or a better approach to any aspect of it to tell us, because there could well be things we just haven't thought of. I hate to admit fallibility, but there it is. We are fallible. So I'm sure I speak for you as well, Ed. We genuinely welcome ideas which are more than tweaks. Ideas which are principled changes.
Yeah, I mean, I would say that one of the evolutions that I've seen has been, of course, issues for disclosure and the models are really important, but that's part of framing the debate. There's a real focus, of course, on Section 2, which is your world, Melina, in terms of making sure that you're really thinking about the data landscape, whether you really need to look everywhere and where are the problem areas and how can you cut it down and reduce the number of custodians, reduce the date ranges. And that's a discussion that really wasn't happening before under Part 31, despite the existence of the EDQ. Because people didn't complete the EDQ, so it was never going to function in the way that was intended. But the DRD is a really important document, and what people sometimes confuse the challenges of completing the DRD is that you put the issues for disclosure and the Model C requests into that document, but that's not really, that's just a repository for it. What is important is the questions in Section 2 on the data landscape. So do put your energies into that part of it, because I think you can really then understand which way both parties are proceeding better.
Thank you, Ed. We actually have a question that has come in, and do you see other common law jurisdictions doing something different that could be used in the pilot?
I've got a thought on that. You do, but you see it at the other extreme. So if you go to an arbitration conference, very often you'll see people talking about the Prague rules, where there's hardly any disclosure at all. And that's a fundamentally different approach to disclosure. But you also see a number of different courts, particularly in the common law jurisdictions, looking at these changes with quite a lot of interest. So in Ireland, for example, they have a request-based approach. and it, that creates all sorts of challenges from an e-disclosure perspective, trying to use requests. And so they are certainly interested in what we're doing here. It's not our job, though, to go out and encourage everyone to follow our lead, but hopefully if they like it, then that will make our courts more attractive, because disclosure was seen as being a problem with England and Wales. And I'm hoping that they're seeing that we're addressing that.
Mm-hmm. Thank you, Ed. Really appreciate it. Perfect. So with that being said, I genuinely hope that the turbulence has quasi-shifted and that most of you have been able to have some really useful takeaways from our conversation. I wanted to thank you all for your participation to our webinar today. Bringing the real experts to the table sure makes a difference, and I'm absolutely certain that this is not the last conversation we're going to have on the disclosure pilot scheme. If anything, you've heard it from our entire panel, dialogue is more than welcome, it's actually necessary. For those of you who have managed to join us live, I hope that you found our session useful. We're always open to receiving more questions from yourselves. You should feel free to post them by way of messaging, etc., on our ACEDS UK page. You can find us on LinkedIn and our profile, and we shall, of course, collate them and be able to address them in due course. I hope you have a good rest of your day. I wanted to thank our wonderful, wonderful panel for a thought-provoking, riveting, dare I even add, conversation. I shall blissfully return you to your evening engagements, and have a good rest of your day, everyone, and thank you once again.
Thank you.